All right, happy Thursday morning to everybody. I appreciate y'all joining me. I really do. Today we're going to talk about my favorite trial topic, and that is jury selection. And the reason it's my favorite is I think it's the most fun. I think it's the most dynamic. It's changing, and I also think it's impossible to talk about jury selection without relating it to other parts of the trial. So we get to talk about things like uh, direct examinations, cross examinations, and closings in the context of jury selection. So this is my favorite talk to do. I didn't realize y'all could hear my music before I started. I was playing some music trying to calm down, and that was because I'm really excited. I woke up really, really excited to talk about this. So for those of you who know me, thank you so much for joining. It means a lot that you're willing to take time and spend it with me. I will do the same with you one day, I hope. If you do a webinar, if you do something, I want to be there and support y'all. For those of you who don't know me, thank you for trusting wherever you found me, whether it was an email, whether it was some friend who told you you should come and listen. Thank you for trusting that person and trusting that I'm going to deliver for you. I'm going to show you something good that you can use. I'm going to be honest with you. I'm going to be really honest. I am nervous today. I am really, really nervous. I'm nervous because right now there's 85 of you and there's one of me. I'm the only one who can talk during this presentation, although I can add some people from my office, which we'll do. But essentially, this is me out here on my own for about an hour talking to you about a topic that is really important to me and I imagine is really important to you. And that scares the crap out of me. I am scared and worried that I'll look stupid, that I won't have anything good to say, that you'll disagree with me. And I'm really nervous that you won't think I'm as smart as I hope you do. Maybe you'll think I'm not such a good lawyer, that I'm not such a good person. That really, really scares me. Plus, I can't look back at now the 88 of you and get any sort of feedback. The chats are nice. I always appreciate them. But I can't look at your faces. I can't tell if Tim Blair's asleep. I can't tell if Wynn Soursby's rolling her eyes at me. I can't see any of that. I also can't see if y'all are like, this is awesome. So I feel very alone when I do these webinars. And literally today, I am alone. There's no one else in my office. This is a true quarantine webinar. So what I'll ask for you to do is give me the benefit of the doubt. Bear with me. Trust that I'm doing the best I can, and I promise to you I will do the best I can, the absolute best. And if you don't like what I've done, if you disagree, if you don't think I'm that smart, please don't tell me because that will hurt my feelings. But I promise to you that I will do a few things. One, I'll be real with you. I'm going to be honest. I'm going to tell you about the really good things that I think I do. I'm also going to tell you about some things that I haven't done well in the past. I'll tell you a story where I really messed up. So I'm going to be real with you, and I'm going to be honest with you, and I hope at a minimum, in about an hour, you all sit back and say, at least Mike told me the truth, okay? All right, I believe everything I just said. I truly do. I don't always say that. I've never said that at the beginning of a webinar. Why did I just do that, though? Why did I just do this? This is essentially how I begin jury selection. I stand up in front of all the jurors and I tell them how scared I am. I tell them that I'm afraid that I'm not going to do a good job. I introduce them to my client and I tell them that I'm really, really afraid that I'm going to let my client down. That the trial's not supposed to be about me. It's not supposed to be about whether I'm a good lawyer or not. I mean, if you think about it, the facts and the law is supposed to rule the day. We all know that's not totally true. And I'm worried every time I talk to the jury that I'm going to let my client down. That the person that's been in pain for however many years, that is going to be in pain for however many years in the future, that I'm not going to do a good job. And that I'm going to fail them. I say that, and it actually, I mean, saying it just, I don't walk around saying this. Uh, Saying it right now makes me, I don't know, it's not choke up, it makes me feel something. And that's because from the bottom of my heart, I want to do right by my clients. And when I tell the jury that, and apparently when I tell y'all that right now, I do mean, I mean, I truly mean it. Um, I care a lot about getting it right. And I care a lot about getting it right in this webinar. So that is truly how I start jury selection. And the reason I do that is because of permission and vulnerability. And I'm not going to get too Brene Brown on you here. If anybody doesn't know who that is, Google her. She talks about vulnerability and fear and those kind of things. But in the context of jury selection, we have plucked 30-something jurors, or however many, out of their lives, made them go through a relatively crappy process of getting huddled into a room, not being able to do what they want to do, probably not getting good Wi-Fi, and then being surrounded by strangers. And then they're supposed to come in and talk about themselves and reveal personal things to a stranger. And that's what I am. And one of the last things I say to the jury before I start actually asking questions is I tell them that this isn't fair. It isn't fair to them, for me, a stranger, to ask them questions for them to have to answer. I mean, what other situation are you in that happens? Some stranger walks in the room and says, I'm going to ask you some really personal questions and it's important. Oh, and by the way, if you don't answer, that judge up there is going to get mad at you. So the reason I do it is vulnerability and permission. If I show the jury that I'm vulnerable, that I'm willing to share things with them, that I'm willing to put myself out there, be real with them, give them the good and the bad about me, I hope they'll do the same thing when they are asked questions. And essentially, I'm giving them permission. I'm saying, look, it's okay to say things that are just about you, whether they're good or bad. It's okay to be yourself here, because I'm going to be myself, because that's all I can do. So I'm going to be myself. I'm going to be real with you. I'm going to cut through all the bullshit, and I want you to do the same thing to me. And that's the only way we're going to get through this together. So a lot of times you hear permission being talked about in the context of, do I have permission to really go in at that witness and cross-examine the crap out of her? Do I have permission to ask for this huge number? This is almost reverse permission. Instead of the jury giving you permission to do something, I think you start jury selection by giving the jury permission. And the only way you can do that is show them. You can't just say, I give you permission to tell me about yourself. Yeah, no shit. You have to show them that you're willing to share things about yourself, so that way they know it's a safe place. I think talking to groups of people in your life and every day and making them feel comfortable, getting to know their names, getting to know who they are, I think that's the best training for jury selection. So when I share that I'm really scared and nervous, I mean, that doesn't feel good. I'm scared about saying that I'm scared. So I think that if I tell them those things, if I tell them how I'm feeling and how I'm worried, and that I might not do a good job and I might let my client down, and that's my biggest fear, I think that gives them, that they at least sit back and say, wow, this guy's, he's not bullshitting us, he's real. And you have to really feel that way. You can't just fake it. You really can't fake it. Juries sense that in a second. So you have to be real and be willing to put yourself out there, because it eventually becomes about those jurors. And if you don't know their true thoughts, their true feelings, you're in big trouble. The official title of this webinar is What Jurors Want to Know, What They Want to Hear. And the reason for that is because I believe that at the end of jury selection, if you do it the right way, you can know how to try your case. You can know how the jurors are going to think. So I'm going to back way up here, and I'm doing this not to bore y'all. I'm not going to go through the mechanisms, the how-to of jury selection. First, it's different in different jurisdictions. Second, I hope y'all know it. If not, don't worry. I'm going to send you my trial brief for jury selection, which I file in every case. I file it before jury selection, and it gives the lay of the land in state court in Georgia about what jurors should be stricken, what shouldn't, how it all works. So I'll send that out this afternoon along with my email. It actually might be tonight, but I'll send it out. So when I say back up, I want to back up to the purpose, because I think if you have the same outlook as me on jury selection, and maybe you don't, that's fine. I'd love to hear your thoughts later. If you have the same outlook on me, I think that the plan or the system of how I do this makes sense. So I hear that the purpose of jury selection, I hear this a lot, is to find out the bad jurors and get rid of them. I don't think that's the purpose. I think that's one tool, one strategy of jury selection, but I don't think that's the purpose. In fact, I refuse to believe that's the purpose, because let's say you have 6 strikes in state court. I can get rid of 6 jurors, and there's 8 jurors that are bad. Talk about what that means later. Bad for my case. Well, I can't win. I can't win jury selection. I can't serve my purpose, because it's actually impossible for me to strike 8 jurors when I only have 6 strikes. So I refuse to consider the game under those rules, because I will lose every time. And I don't think that's the purpose. I also hear that on the other end of the spectrum is the purpose of jury selection is to try my case to the extent I can and try to get the jury on my side. I don't think that either. I think that there's practical problems of that. First, the defense lawyer, if they half know what they're doing, they're going to object to a lot of those questions that you would have to ask, or those statements that you would have to say to prove your case or show your case. The second thing is practically, I don't think you can. You can't show evidence in jury selection. I can't put up witnesses. So what are you going to do? Talk about a piece of evidence? You tell the jury that this dude's credibility is crap? It just doesn't make any sense to me. I also generally think that a lot of people look at jury selection as, well, I want to learn about the jurors. I want to learn about them. I think that's true, but I think you should take it a step further. So here is what I believe the purpose is, and I'm going to say this a few different ways, hopefully so it connects with you. I think that the purpose of jury selection is to learn from the jurors what they think is important and how to try the case. Let me say that a different way, but it's still the same meaning. The purpose of jury selection is to present the jurors with the issues in the case and find out what they want to know to make a decision. All right, one more time. I'm going to do same thought, same meaning. The purpose of jury selection is so that you know what the jurors think are important about the specific issues in your case. I hope those 3 statements, at least I think, those 3 statements mean the same thing. But I believe that the purpose of jury selection is to do that, is to make sure that when you walk out of there, you know what every juror thinks is important and how they will decide, their mental process, how they will decide that important issue, what they want to know, what they're going to think about it, how they're going to weigh the evidence. So how the hell do you do that? In my office, and this is the only way I know how to do it, we play a game. It's called Good Fact, Bad Fact. You write down all the good facts of your case on one side of the paper, and you write down all the bad facts on the other side. This is a topic for another day, but your good facts are going to form the basis of your win statement. I didn't say theme, but you can call it that. I don't believe it's a theme. I believe it's a win statement. To me, a win statement, theme, is a statement that is, if true and the jury believes, you should win. If it's a true statement, the jury should believe it and you should win. That's what I believe a win statement is. I don't want just some theme. I want a win statement. But anyway, so that's what I do with my good facts. With my bad facts, that is how I form the basis of jury selection questions and topics. So, talking about being vulnerable about yourself, you have to be vulnerable about your case. You have to be vulnerable about your case. When I walk into jury selection, I am almost always only going to talk about the bad things in my case. I'm not going to say anything good about my case except that my client is awesome. And the truth is, sometimes I hesitate to say that. So when I look at my bad fact list, and it will be pages, what I want to look at is what I want to consider is what are the topics that can change the outcome of the case. And maybe it's not just one topic, maybe it's a combination of a few that work together. So I had a case where my client was injured, gets picked up by the ambulance, and the records from the ambulance are completely wrong. How he was hurt, where he was hurt, all wrong. So the story in the medical records, starting with the EMTs, is completely wrong. He then's transported to Grady Hospital, met with a trauma team. That story is transferred from the paramedics to the trauma team, to the surgeons, to the nurses, to rehab, to the clinic, to his primary care doctor. And in a couple thousand pages of records, there are hundreds of instances where this story is wrong. Hundreds. So I have to get up and tell the jury that these medical records are wrong. I have two options. I can hide from that and run from that, or I can tell them right at the start, this is what it is. So one of the first things that I say to the jury in jury selection is, you're going to hear that what my client said is true, what his story is totally different than the medical records. And it's totally different than what's in the medical records hundreds of times. Now, let me stop you, or stop me. Am I allowed to do that? Am I allowed to tell the jury what the facts are going to be in the case? Maybe. Has a defense lawyer ever objected to me when I tell the jury something terrible about my case? Nope. If I stand up and say, the records are, there's these medical records, and they say hundreds of times that my client is lying about the story, who in the world is going to stand up? What defense lawyer is going to stand up and say, Judge, the jury shouldn't hear that the client is a liar, that the client didn't tell the truth? I once had a defense lawyer do one of these ones where he went, I saw it out of the corner of my eye, he goes, and sat back down because I'm saying bad things about my case. So can you say this? Maybe, but practically, on a practical level, is anyone going to give you trouble? No, I don't think so. And no one's ever given me trouble, okay? So I say to the jury, these medical records are wrong. Has anyone ever seen their medical records? And I get some hands. Then the question becomes, how do I figure out, and this is what I'm thinking to myself, how do I figure out what these jurors will want to know about this situation to figure out if my guy's the liar or if the medical records are just wrong? So I'm not trying to prove to them in jury selection that the medical records are wrong. I'm actually, in a way, I'm trying to get the defense's case even tougher. I'm trying to make their case easier. I'm trying to make their case be this huge burden that they're going to show this, and then I'm able, hopefully, to destroy them. So how am I going to figure out what the jury will think? Well, I ask them. I say, what would y'all want to know? Can anybody share anything with me that they would want to know that would show that medical records may be wrong? Well, a witness raises his or her hand and says, well, I'd want to look at the medical records. I said, okay, that's great. Who else would want to look at the medical records? Get more hands. Why would you want to look at the medical records? Well, I'd want to see what the story says. Okay. Well, after you see what the story says, what else would you want to know to be able to compare that and see if it's true or not? Well, I'd want to talk to the paramedics, the first responders. Hey, that's a great idea, Juror 12, Ms. Smith. What else would you want to know? Does anybody else want to know that? Oh, yeah. We should also talk to the police officers. We'd want to hear what they say. Mr. Jones, that's a phenomenal idea. Thank you for sharing that. Anybody else want to talk to the police? Oh yeah, me too, me too. Would anyone want to hear from any witnesses? Oh yeah, the witnesses, that'd be great. What if there was video? Would you want to see it? Yeah, I'd love to see the video. What you're doing is, in a way, you're eliciting what the jury wants so that you can go do that. And in another way, you're suggesting things to the jury in an honest, truthful way, a helpful way, about what you think they should know and what you think they should care about. Now, you have to have these things. You have to have the 10, 20, 30 things that the jurors are going to care about, or you need to be real with them and say they're not going to see that. And you may not be able to do that until the closing argument. And you say, look, there's probably 20 things that would be important here. Only 10 of them exist. So I think you want to take your bad facts and you want to figure out what the jury wants to know. Now I'm going to show you a little example here. For those of you who were in the chat early, you saw that I was setting up my two lawyers in office, Chris Stokes and Chris Jackson, both with terrible facial hair. There's one. That's not the bad facial hair, folks. That's actually not. Wait for it. Wait for it. There's the bad facial hair. There it is. Chris Jackson, you're muted, so let's let you. All right, good. So what I want to do is, this is going to be a very small sample of how this works. I promise you, and whoever was in the chat early can verify this, they do not know what I'm going to ask them. They didn't know they were going to be involved in this. They didn't know any of that. So we got a guy from Napoleon Dynamite with the mustache. And then we got a guy who's, I was going to say building bombs in his basement. I don't think I can say that, so I won't. Right. Yeah, that's exactly the reaction I was expecting. So y'all are jurors, okay? And be real with me, okay? Just answer like you would. Try your best not to be a lawyer. Best as you can, okay?
All right.
So here's the quick background of the case. Here, Stokes, tell me, which case do you want to go? Give me a name.
Perry.
What are your cases?
Perry.
All right, Perry. So this is a car crash case. It's 3 cars, okay? So let's imagine we're going to approach the topic of which car is to blame for the crash. There's 3 cars involved in this crash. Our client's rear-ended by 1 and then 2 people. So here would be my questions. If I'm thinking to myself, how am I going to figure out how to prove to the jury that we weren't at fault, the other 2 were, or maybe I'm trying to figure out how to get more on one vehicle, which in this case there was a commercial vehicle, versus a different passenger car. So here we go. Mr. Stokes, have you ever been involved in a crash before?
I have.
How many cars did it involve?
It was just 2.
Has anybody been involved in a crash that involved more than 2 cars? Mr. Jackson, have you?
I'm not.
All right, so no one here has been involved in a crash with multiple cars, and that's a good thing. I'm glad y'all are safe and healthy and getting through Atlanta traffic. But this case involves 3 cars, and those 2 cars that are defendants, those 2 people are saying that it was our client's fault. It's 2 against 1. So what I want to figure out from y'all is what you think is important to evaluate who's responsible for causing this crash. Mr. Stokes, can you think of anything that you would want to know to figure out who was at fault? I know you don't know anything about the crash, but what kind of things would you want to know?
I want to know what the police officer said.
I appreciate you sharing that. Mr. Jackson, would that be important to you too?
Oh, absolutely. Yes.
Well, let's talk a little more about the police officer. What kind of things would you want to know to tell or decide if he was a good witness, meaning he had good facts and he knew what happened? How would you evaluate that? What would you want to know about him?
Well, I'd want to know how long he'd been a police officer, maybe.
Okay. Along with that, would you want to know how many crashes he had?
Absolutely.
Mr. Jackson, I saw you say that you'd want to know how many crashes he's investigated. Why would you want to know that?
I think experience matters. If it's just his first time ever figuring that out, let's say he shows up to the scene and two people say it's your client's fault, maybe he would just go for that, or maybe he wouldn't do his own investigation beyond that.
I appreciate you sharing that. How would you tell, what would you want to know about his investigation? What are some things that might be important? Can y'all think of anything?
I'd want to know who he talked to and, exactly what they said to him.
Okay. Who could you imagine that he would talk to?
Well, other than the drivers, if there was any other witness, I'd be very curious to know what they would say.
Mr. Stokes, would that be important to you to figure out what the witnesses told the police officers or what the drivers told the police officer?
Yeah, absolutely.
Can you think of anything else? Either one of y'all, can you think of anything else you might want to know?
Well, I always see on TV that they're measuring tire tracks and things like that, and I'd want to see if the police officer did something like that.
You mentioned tire tracks. Can anybody think that skid marks could be important on the ground?
Yeah.
Sure.
How would you be able to tell if there were skid marks?
Take photos of it.
Okay, photos. So could photos be important?
Yeah.
Absolutely.
Can y'all think of anything else? You mentioned the expertise of the police officer. Would you want to know if there were any other police officers that also came to the scene?
I would. I'd want to hear from all of them if they all showed up.
What if you were able to hear all that because there was a dash cam or a body-worn camera? Have you all seen those before?
Yeah.
Yeah, on the news. And I think that would be maybe even better than just hearing from the officer.
You mentioned that you think that would be better than hearing from the officer. Out of the things that we've talked about, what would you value the most? What do you think you'd place the most importance on?
It may be that video, because then I'm not taking anyone's word for it. I just see the scene myself.
I appreciate sharing that. Does anybody here have a different answer to that question? Anybody think anything different? Mr. Stokes, what do you think?
Yeah, the camera may not show all the angles that I want to see or anything like that. So if the police or anybody that was involved in the crash took photos, I'd want to see those too.
So what I'm hearing from y'all is that you'd want to know who the police officer was, what the police officer's history and training was, how many crashes they've investigated, as well as you'd want to know what the witnesses said. If you can see those things, whether through video or picture, you'd want to do that. Can y'all think of anything else that you'd want to hear? Who else would you want to hear from?
I want to hear from the drivers. If one driver says that the other two drivers are at fault and two drivers say that she's at fault, I want to hear why they think that.
Well, I got good news for you, Mr. Stokes. As you can see, everybody's in the court right now, and everybody's going to be here the whole time, at least my folks are, and we're going to be able to talk to all these people. Does anyone else think that would be important, to hear from the actual drivers? Now, what if I tell you that the drivers disagree with the police officer? That the drivers say, all of them, all three, say that the police officer got something wrong. How would you be able to figure out or evaluate who's telling the truth or who got it right, who got it wrong?
Oh, I would think that if everyone said that the police officer was wrong, that because he or she wasn't there, they might have actually gotten that fact wrong.
Okay. I'll tell you, I'm really worried about something in this case, and that's that there's a lot going on in the world. In truth, right now, there's a lot going on in South Georgia about a shooting, if y'all haven't heard about that. And there's a lot of strong feelings about police officers. I have strong feelings about police officers. I have very strong feelings about police officers, some good and some not so good. I will tell you that I've met with great police officers, ones that I want to be like almost. I've also been on the other side. In law school, I was arrested. So I've been as bad as this can be. So I've had good experiences and bad. Have any of y'all had any experiences, either good or bad? I'm not asking what they are. Have y'all ever had some good or bad experiences with police officers, personal?
Of course, yeah.
I've had both, right.
Okay. If you're willing to share any of those experiences, we would go down that road. All right, guys, thank you. So, all right, I'm going to take y'all off. Can't look at Chris Jackson's beard anymore or whatever that is.
It's a generous thing to call it.
All right, let me see if I can get y'all change role to attendee and change role to attendee. All right. So that is a very, very off the cuff way just to show you, get you a flavor for it. So the flavor here is that I've got a team. Someone asked way early on, how do I, let me see if I can find that. How do I write things down during jury selection? How do I organize my thoughts in real time? I don't write anything down because I'm not capable of listening and writing things down. I think listening is the most important thing in our entire jobs and maybe our entire lives. So I only care about listening, but I will never do jury selection alone. I will always have a team. The last jury selection I did, I had another lawyer, actually I had 2 lawyers. My client, I don't remember who, I think Chris and Chris were definitely there, I'm pretty sure, in the behind the jurors, writing things down too. So I have a team that helps me listen and helps me do that. I'm listening for the answers. I'm not thinking about what I'm going to say next. That's really, really tough. I am truly, truly listening and trying to connect with people because I care about what the answers are. I truly care because I need to know. What I learned even in that little touch of it that we just did, I learned, and a lot of this may be obvious, I learned that the jury will want to hear from the police officer. They'll want to know what the police officer's expertise was, how long they've been a police officer, how many crashes they've investigated. I know there's at least one juror, and here's what shows you how I was listening. I know this was said, I don't know by who, so I would have a team telling me later, oh, Chris Jackson was the one who said he'd want to know about the measurements. I think it was actually Stokes. But I want to know what jurors specifically want to know things, what specific things they want to know. The reason for that is because later I'm going to try to connect the dots with those specific jurors. So I know about that they want to know about the police. They want to hear from the drivers. I'm pretending my defendants are sitting over there and the plaintiff's behind me. They want to know about the actual investigation, the drivers, the photos, the body cam, the dash cam. Now, there is no body cam or dash cam in this case. So what do I have to do? I have to stand up during opening statements and say, ladies and gentlemen, I'm going to bring the police officer and he's going to testify. You're actually going to see him via video because he's out there protecting people on the roads. But his testimony is going to be just like he was in court. Now, while he's going to be in video, you're not going to see any video. You're not going to see any photos. Police officer didn't do that. If it was here, I'd show it to you, but I can't. I'm going to show you everything that I can possibly think of, so that way you can evaluate the case. I can't make things appear, so I can't show you that, but I am going to show you these things. I'm going to tell you, you're going to learn how much experience the officer has. You'll hear about his training. You hear he's investigated over 5,000 crashes. You'll hear that he looked down and saw skid marks, and that showed this to him, and so on. So right from the jump, right from the beginning, I am writing everything, or I say I collectively, we are writing everything down that is said with each juror. So that way, when I say if Chris Stokes makes my jury and he's the guy who talked about the measurements, I can look at him when I ask the question. Let's imagine that the police officer's live or even in closing arguments. I can look directly at him and say, you want to know about measurements. Well, if you look at the second page of the police report, here it is. Look at the second page of the police report. You'll see that there was measurements for the skid marks. You'll see that the police officer did a really good job. And the police officer out there doing CSI stuff. And he's doing this in the middle of rush hour traffic in Atlanta. And I'm looking right at Chris Stokes because I'm trusting him. I'm entrusting him. I'm giving him that information, and I'm asking him, non-verbally, I'm asking him to protect that information. And when that comes up in the jury deliberation room, his job is to then go deliver that information to the jury. We'll talk about closings at some other time, but I'm looking to arm jurors with information. So that way, when it's needed, when it's necessary, they can take that information that I've entrusted them with and fight for me in the jury deliberation room. Because I can't go back there. When I say fight, I don't actually mean fight. I had a case where there was a mistrial because two jurors beat each other up. I don't actually mean fight. But I do want Chris Stokes to stand up when somebody criticizes the police officer and says that investigation was crap. Chris Stokes says, what are you talking about? That guy went out there in the middle of rush hour traffic and measured the skid marks. He wrote it on the report. I mean, he's a good cop. I was in this crash once and the officer didn't do that. So I now know, and I have a list, I will have a list of all the things that the jurors want to know and who wants to know them, all the things they want to know about this important issue of how to tell who's at fault. And then I can use that information to either remove jurors. If some juror says, I can't find for you, I won't be able to I won't believe the police officer unless there's video. Well, I might not want that juror, or I may. But I'm able to know specific things about the jurors so that I then know how to try my case. Especially with live witnesses, I need to know how to ask them things and what the jury wants to know. I'll tell you an example of one. Bobby in the chats asked, most judges will not allow lawyers to get into such extended banter. So I think you can, got to be careful of the word here. I think that you can convince most judges to let you do that. Or you can still do this, even if the judge won't allow you the free flow. So stick with me for a second here. My preferred way of doing jury selection is, judge, give me however long and let me ask whatever I want to ask to any juror at any time in any order, so that way I can have a free flow of information and I can talk with jurors and compare and contrast them. I can say, does anybody agree with Christopher Stokes? Does anyone agree with juror number 12? Does anyone have another idea? I want to do that. How do I do that? Well, some judges just allow it. If the judge allows it, I'm in the clear, obviously. If I don't know, I'll find out what the judge does. And if the judge does not typically allow that, I will say to defense counsel, hey, how do you like to do jury selection? I like the free flow. I like it's quicker, it's easier. I like to just do all my questions, general and specific questions right away. You down for that? Most times they say yes. So then I present the idea to the judge. And I say, Judge, this is the preferred way. I understand it may make you uncomfortable that there'll be some sort of tainting of the jurors, but if you read my trial brief, you will see that it's more important to make sure that there are no tainted jurors, that there are no jurors who have strong biases, and the only way we figure that out is by truly talking to them. And judges kind of typically balk. And then I say this. I say, Judge, it's going to take me 4 hours to get through jury selection if we do general questions and then specific juror questions one by one. It's going to take me hours. I can do it in half the time if you give me the full room. I can do it in 2 hours if you give me the full room. I don't know. Okay, I can do it in an hour and a half. I once did jury selection, and I had to have the right case. I once did jury selection where I said, I'll do it in under an hour if you let me have the full room. So I think there are ways to convince the jury or convince the judge to let you, especially if there's no objection from the other side. I also think that even if you have to do general questions and then do the specific questions juror by juror, there's nothing wrong with saying to juror Smith, hey, juror Smith, you heard what juror Jones said. Do you agree or disagree with juror? What do you think about that? So it's a much longer process, but I think you can do that. All right. I want to tell you all about a story that I got wrong, and that when I was first kind of buying into this concept, I focused mainly on doing this for liability issues because I think that's easier. It's easier to try to figure those things out. What I didn't really embrace was how to ask the jurors to tell me what they want to know about damages. So I had a case where my clients were walking down the road. It was a husband and a wife and 2 of their kids. They had 3, but 2 of them were walking and then a dog. And this is right on Old Ivy Road, right behind Howell's. And they're walking in the morning on a weekend. And a truck, a pickup truck, jumped the curb trying to make a turn or something. And the bed of the truck actually hit them. Didn't hit the wife, she was okay. Hit the husband, he went flying into a bush like 6 feet. And then the kids were knocked down. There's a big commotion. Truck drives away, by the way. But there's a big commotion. Neighbors and everybody come out. Police and ambulance comes. And they check the kids. They're fine. Check mom. They're fine. And they decide they're going to bring the husband, who's flown 6 feet in the air, for testing and to the ER at Grady. And he gets a ton of tests. I don't remember what his medical bills were. I mean, they did a good amount of tests, but he was discharged in a couple hours. So, I mean, what were they, 15, 20,000 bucks, maybe? So I have a trial, and during jury selection, I was asking the jurors how they would want to figure out pain and suffering. And I knew at that time that I had 3 really good damages witnesses. I had 3 friends, the family, who were going to come and talk about the effects, the emotional effects that this had had on the family, specifically the kids, and how it had changed kind of their daily life. And I didn't ask the jurors, and I wish I would have, I didn't ask the jurors whether they thought damages witnesses, before and after witnesses, were important. So when I was going through my questions of how would you want us to prove pain and suffering, and we talked about things like how long was the injury, how bad was it, what were the emotional effects. And I know in my head I have these 3 really good witnesses, and I failed to inject into the conversation, because to some degree you are, to some degree, leading the conversation. I failed to inject into the conversation, well, would you want to hear from non-family members about how this has affected them? And I wish I would ask that question, because fast forward, get done with the trial in a day and a half, and the last witness is the mom, and mom is an amazing witness. And I'm feeling really, really good about that. And then it becomes decision time. And literally, there's 2 damages witnesses out in the hallway, and there's 1 on the way. I mean, they were there. I was ready for it. And I made the decision to not call them, because I thought that the jury was with me. I thought that they appreciated how fast we moved the case, and I really liked the ending of mom's testimony. And I decided not to call it. Talked about it with my clients. They were involved, but we all agreed. But ultimately, it's my decision. Talk about letting clients down. It's my decision. So jury deliberates, and they come back. There was a $500,000 policy. There's 4 plaintiffs. Well, there's 4. Mom's a plaintiff, but I mean, I wasn't expecting anything from mom. I was hoping for something for the kids, and I thought I'd get something for the dad. And I asked for $500,000 bucks. That's the policy. Jury comes out, and I forget exactly what they awarded. It was like $210,000 or $230,000 combined. And the jurors were, great. Talked to them after, and I said, what could I have done? And what I learned was that there was half the jurors were thinking, I wish we could award the $500,000. I want to do that. The other half were saying, it's really tough for me to award $100,000 because, there's no medical bills. These people are generally okay. And I said, what would have changed your mind? They said, we wish we would have heard from non-family members. We wish we would have heard from friends or teachers or somebody. And I knew I screwed up. So looking back, if I had more information, if I knew how the jury was going to consider what they wanted to know, you would want to know from a non-family member, and so one of these witnesses was uncle, even though he wasn't, but you would want to know from a non-family member. If I would have asked that question and injected that topic, I would have known how the jury wanted me to try the case. That way, it's not a me decision. It takes the decision out of my hands. If the jury wants to know this, so if I can do it, I got to do it. If not, I have to explain why I didn't. But I didn't know that piece of information because I failed to ask the question. So once that happened to me, I fully bought into this system. I fully bought in because I said, if I can find out what the jury wants, then I can give it to them. If I can hear what the jury's thinking in their head by making them say it out loud and anticipating their thought process, I can do that. I truly believe that this system is way better than the crap of asking, what TV shows do you watch? What newspapers do you read? All this crap. It makes me think of the way I used to do jury selection. I think of the way majority of people still do jury selection is you have to be like Russell Crowe in A Beautiful Mind, or more updated reference, Carrie, whatever her name is in Homeland, when she's like strung out and connecting these random dots. I'm imagining like a room where instead of this picture I just hung up, I'm imagining red string everywhere with people's faces and pictures and locations. That's what I used to have to do for jury selection. I bet that's what a lot of you have to do right now. You have to say, okay, well, this guy is a teacher. He's originally from Florida. He watches Fox News, but he rolled his eyes when he said it. He has never been in a crash, but his wife was in one and she made a claim, and he seems to like police officers. What the hell am I supposed to do about that? Like, what does that tell me? This system, I will be able to say that juror 12, let's call him, juror 12 thinks that it's really important for us to hear from the police officer, for him to know the experience. He thinks that if there's video, that's really important, which is great because we have video in this case. He thinks that young police officers aren't as trustworthy. Well, that's tough because this police officer is kind of young. He wants to know how long the police officer took to get to the scene. How long the police officer took to get to the scene. So I can take what the jurors want to know, and then I can apply the facts to what the jurors want to know. And instead of categorizing jurors as good jurors or bad jurors, because it's not good or bad, I'm classifying jurors as that juror, what they want to know, what they value and think is important. That aligns with the information that I can give them. Going back to that medical records example where I said my client had all these medical records and they were wrong. That conversation that I had with the jurors, and that's what it was a conversation. I was asking jurors, how would you want me to show you that the medical records are wrong? And come to find out, there's one juror who says, I had gotten my medical records once and they were wrong. Have another juror who says, I'm a nurse practitioner. I see medical records. Does anybody in your office ever get anything wrong? Yeah, well, how do you tell? How do you know that? She says, well, sometimes the patient tells me that it's wrong. Well, awesome. I'm thinking to myself, my client over here, he's going to tell you the records are wrong. Plus, there's other facts. It's not just him. There were other facts that could prove that. And then down the line, those two jurors made my jury. And I'm looking, because they were bad in every other regard. They were bad in every other regard. They're saying too many lawsuits. They're saying $1 million is an incredible amount of money. There's no way they're ever going to be able to award that much. They're saying all those things. But there's one issue that I care about. They are my jurors. And the reason I knew that is because I had a dialogue with them. So when closing arguments come, I look right at them, and they ended up sitting right next to each other, back row. I can look at them and say, for those of you who have experience with medical records and working in doctor's offices, y'all know sometimes medical records are wrong. Y'all know that. So when you go back in the jury deliberation room, it's your job to go tell the jurors, the other ones, how this works. And if somebody pushes back and says, no, there's no way those records are wrong, explain to them that it's not hundreds of pages of records that are wrong. It's one story that paramedics got wrong when my client was completely in pain and injured and didn't want to talk. And tell them how that record gets repeated over and over and over and over. And explain to the other jurors, remind them all of the independent evidence that shows that the records are wrong. If you have that experience, that's your obligation. That's your job here. That's your job, is to make sure that truth comes out, and you are the arbiters of truth in that issue. That is your domain. So you are the experts in that issue, and make sure that you speak up for that. Make sure you don't let people get it wrong. I'm able to do that. I'm able to do that in closing arguments because I know that those two jurors think a certain way, want a certain thing, and I gave them that certain thing. In another trial, I learned that jurors thought that one witness, the category of witness, was far more important than another witness. And specifically, I'm not talking about the jury panel. I'm talking about we pick our witness, we pick our jury, the jury gets seated. The next day we do openings the next morning. That whole night, what I'm doing is I'm looking at everybody's notes from the jurors, and I'm saying, okay, how many of them want to know this? How many of them want to know this? How many want to know this? And when I'm looking at those particular 12 jurors, 13 jurors that are on my jury, they're them compared to the jurors who didn't make it. They want to know something specific right up front is what I gathered, because that's what they told me. And I switched my witnesses, and I said to myself, I'm going to call this witness first instead of the other one, because that's more important, and that's what the jury wants to know. So when I walk out of jury selection, I literally have a roadmap of how to prove my case, what these specific people want to know, and how I'm going to do it. And then I can change things. It also means that by the end of jury selection, the jury knows all the bad stuff about my case. I didn't get up and say, I'm going to prove this, I'm going to prove this, I'm going to prove this. I'm the greatest. I said, I am so worried about these things. Here's what I'm worried about. This issue, this issue, this issue. Tell me how to fix that issue. Tell me how to present that in a way that you will believe me. And the jury leaves that experience probably thinking my case stinks. And I'm totally cool with that. I want you to think that I have the worst case, because then I can exceed your expectations. And it's so much easier for me to do that. It's the same reason during opening statements. And for my cases, I generally have very, very good defense counsel, so it's easy for me to say this. Those are the best defense lawyers that money can buy. They are phenomenal. Look at that guy. My last case was against Roger Harris. Roger Harris has tried more cases than I'll probably ever try in my life because of his experience and the kind of cases he handles. He's a great lawyer. You're going to get the best defense from him imaginable. And then there's little old me who's going to try to prove my case. So if you do this the right way, you know the playbook, you've made the end zone closer, you've made your case easier, and you've made their case much harder, much harder. The last thing I'll say, last example I'll give you is, I call it the money man example. And this is a case that Wynn Sowersby was actually the clerk, if she's still on here. She was the clerk for Judge Besson when I tried this case. I had the most experienced, educated jury that I have ever seen. Fulton County jury. This is a gas station shooting case. If you haven't done a gas station shooting case, you're probably smarter than I am. I shouldn't have done this gas station shooting case. I mean, now that I know the result, I should have. But right now, if this case got offered to me, no way in hell I'm taking it, because I was out of my mind. I was also young, and I thought I could do anything. So I thought I could convince people of things. I don't know if that's true anymore. I have a juror. We're talking about how to value pain and suffering. So I bought in at this point to, I'm going to ask the jury how to try my case. And I'm saying, folks, how can I show you that there is continued pain and suffering? What do you want to know? And literally there is a guy who's a Georgia Tech professor, and I'm pretty sure he was a rocket scientist. Like, no joke. He was like a rocket scientist. And he says to me in jury selection, and he perked up. And when we started talking about numbers, he perked up. And he said, I would want to know, I'd want to assign a monetary value to it. I want to assign a monetary value. And I'm like thinking to myself in my head, shit, this is the one thing I don't want to do. I don't want to put a per diem on this case because I don't think that helps me. But you have to have no fear in this, and I'd rather know that a juror wants that. So either I can keep him or get rid of him, or I can figure out how the hell I'm going to do this by the end of the trial. So he says to me, I would want to know some mathematical formula. And I said, sir, I don't know if I'm going to be able to tell you that. You are smarter than me. You're the rocket scientist. said, I have a political science degree. How the heck do you want me to do that? What do you want to know? And he says, well, you know, when I travel, I get a certain amount of money. I'd want to know, you know, some sort of equation of how I'm going to figure that out. And I obviously know, you know, per diems in my head. And I say, all right, and you got to be real. I say, look, okay, so it sounds like you want a per diem. And he goes, yeah. And I said, that would be per day. I said, does anybody else want a per diem? And all these damn hands go up. Now, you might be thinking, why'd I ask that question if it's not good for me? Because I want to know. I want to know if I got a problem here. All right? So all these hands go up. I'm like, okay. So then we have a conversation with everybody about this per diem and how you value it. Do you do it per hour, per day, per week, per month? I mean, we get into the nitty gritty. How do you value it from the time he's hurt compared to 10 years from now? I mean, we go through all that. This overtook the jury selection. That rocket scientist makes my jury, okay? I have a jury with, if we want to talk demographics, with 11 white people and 1 Haitian guy, and I have a African-American client who's shot in a bad neighborhood. So I don't have the great demographics. A lot of people said I had a bad-looking jury if we're using demographics. But I had a jury that I knew what they wanted to know. So fast forward to closing arguments. I now know what the jury wants, and I know I have a money man. That guy, the whole time when I'm talking about everybody, or talking to everybody about the jury, I'm like, oh, I got that money man. I got that money man. So every time I'm talking about the medical records or the medical bills, when I ask my client, I say, how much are your medical records? Or how much are your medical bills? I'm looking at the money man. I'm looking at him. When I say to the doctor, you know, are your medical bills, are they reasonable? Are they necessary? Even though they're that expensive, are they reasonable? I'm looking at the money man. So fast forward to closing arguments. Let's see if I can do this. My plan is to stand in front of the jury, and my plan is to say, here's how much I think the case is worth. I wasn't planning any sort of math, any per diem. And the reason is I couldn't think of a great way to do it. I spent years, literally 2 or 3 years, thinking about how I'm going to do this, and I couldn't figure out a good way. Funny enough, when trial is literally there, not on the horizon, when it's there, you'll figure out a way. If a juror tells you, I want this, you're going to have to figure it out. So here's what I do, based on what I know about the jurors. I do my thing, where my typical thing is something like this. I'll go to a wall. This is right where this is actually the wall, the front of the courtroom where the judge is. And I'll say to the jury, this right here, this space, this is a car crash, rear end, go to the chiropractor, you feel fine. In pain and suffering, and this is the context, we're talking about pain and suffering. In pain and suffering, this right here is worth $25,000. Now you can agree or disagree with me about that, but that's what I tell them. This is $25,000. Now I walk all the way to the door of the courtroom. My door is right here. I walk to the door. We're behind the gallery. I'm back there. And I'm yelling. I put on a little show. And I say, this right here, this is someone who's killed. This is someone who is paralyzed. This is someone who has a brain injury that they can't function. And then I walk all the way back, and I get to, I don't know, it was about 5 feet from my original spot. And I've said that those cases are worth millions and millions and millions and millions and millions of dollars. If you're killed, you're paralyzed, or you have brain functioning problems, you are worth millions. Okay? And then I come way back over here and I say to the jury, this case to me feels like, and I'll talk to you, the last thing I'm going to talk about is expertise and honesty. I felt like I had built those things, those expertise and that honesty. So I say to the jury, look at the spot, the $25,000 spot. I look at the millions and millions and millions of dollars spot. I say, this looks about right to me. The pain and suffering in this case is worth $1.5 million. It's worth $1.5 million. That's what feels right to me. Now, here's where you got to be honest. But I don't know. There is no perfect way. Now, I'm looking right at my money man. I'm stepping forward. I'm looking right at him. And I say to the money man, some of y'all want me to tell you a perfect equation, a perfect math way to do this. I can't do that. I don't know how. There are jurors, looking at my money man, there are jurors who are way smarter than me. Way smarter than me. I'm the one with the political science degree, remember? Reminding them about that conversation at jury selection without actually saying it. I'm the one who has a political science degree. So here's what I think you can do. You can take a multiplier of per day, per hour, per minute. I'm going to use per day because that's easier for me to do the math, but you have somebody, still looking at my money man, you have someone who can break it down to the second. And here's the numbers that I think. And I've got a whiteboard and I do my thing, write down my numbers. Magically, my numbers, I believe, were 1.2 to 1.7 in pain and suffering. I gave them a range per day. I had to use two numbers, which I didn't want to do. I had to use this is how much it's worth until this point in his life, and then it's going to be worth less later. I didn't want to do that. I had to do it because the money man wanted it. So when I do that, magically, I've got a range of 1.2 to 1.7, and I say to the jury, look, y'all, I'm standing here. I think the case is worth 1.5. I think the pain and suffering this person deserves is $1.5 million. The math says it may be more. It also says it may be less. I'm going to leave it to y'all because I trust you, and I think that you can handle it. Come to find out, the jury awards $1.7 million. That reinforces the idea to me that you have to do what the jury wants. You have to do what the jury wants. The last thing I want to talk about is honesty and expertise. I think those are two very important things during jury selection. The expertise factor is no matter how many times you've done it, you have to act like you've been there before, and it is second nature. To this day, when I prep a client for the trial and for how to act during the trial, specifically during jury selection, I practice having the client come to my office, stand up, move their chair around so that they're facing the jury, sit back down, imagine the jury's walking in, think of the face you're going to make, and then practice standing up and having some sort of open body language to the jury. Okay? Closed body language, open body language. You're more trustworthy if people can see your chest, your torso. Why did I do that? Why do I still do that? Because I want the jury to come and say to me or think of me as, oh, this guy's in court every day. This guy knows his stuff. It's the same reason I want to know the names of everybody in the court. The same reason that I want to tell the jurors what's going to happen during opening statement. And the same reason during jury selection that I want to feel comfortable. I want to feel comfortable. And the best way I feel comfortable is telling them that I don't feel comfortable, like we did at the start. And in terms of honesty, if you are honest with the jurors and give yourself to them, you allow them to get to know you in the very short time that you have with them, and you're real with them. You're real with them. You say to them, this is unfair. I don't have enough time to get to know you. I'm sorry, I wish I did. But I'm here to serve a purpose. I'm here to serve this client. I hope I don't fail them. And you continue that honesty. Then during closing arguments, and then during mainly, I guess, during closing arguments and also during directs and crosses, they will believe you. They will believe you. So the three things I'm doing during jury selection, the number one thing, the most important thing, is I am finding a playbook, a roadmap for how to try every issue. The way I'm doing that is I'm doing good fact, bad fact. Good fact goes to my win statement. Bad facts, those are the things I want to know about. Those are the issues I'm going to talk to the jury about. And then I'm going to have absolutely no fear, no outward fear. I'm going to ask the jury about my bad facts, and I'm going to tell them about them. And I'm going to find out how they want to know, how they are going to evaluate those things. What do they want to know? What's more important? What's not? And I have to have no fear, because even if a juror says something that I don't like, I got to go with it. You got to keep going with it. You've got to address it. By going with the bad and diving in and learning what the jury wants to know, what specifically those jurors want to know. That's why this is better than a focus group. You're learning what those jurors, the ones who are truly going to decide your case, you get to know what they think. And then you get to make changes and adapt. and try your case in the way that the jurors tell you to do that. You as the lawyer, I think, you are the third most important person in the courtroom. Jurors are the most important. The parties are the second most important. And you are the third. Judge is the fourth. You are the third. Bailiff might even be in front of the judge. But you are during that trial, that's what the jurors are the ringleaders. I mean, they are in charge. And if you're trying to get them on your team at the end of the case and trying to get them to work for you, you have to be able to empower them, and you have to know what they think about the issues. You don't need to know what they think about the bumper stickers on their car, the news that they watch, all that random crap that doesn't actually tell you anything about the case. Get rid of that. Try to focus on your issues, your bad ones. You don't need help proving your good ones. And then at the end of the case, if you give yourself, if you treat people respectfully, and you welcome them in. The way you do that, by the way, you saw a little bit of it in the example that with the Chris's from my office. I'm saying I'm looking eye contact. I'm listening. I'm not writing stuff down. I'm looking directly at the juror who's speaking. I'm making eye contact. I'm nodding when appropriate. And when they're done speaking, I'm thanking them, truly. I am thanking them for sharing that with me in the group. And then I'm asking if anyone else wants to share. And to some degree, I'm sharing things about myself so that the jurors look to me, one, as the expert, two, as the person giving them permission. I'm giving them permission to talk about themselves and say things that they wouldn't tell a stranger. If you do that, I think you will try cases differently, because you will do it the way the jury wants you to, not the way you thought it was right, not the way your client wants you to, not the way that the defense lawyer isn't trying to. Hell, not even the way that the focus groups told you to try it. Who cares about the focus groups? I care about those jurors. And that's what this essentially is. It's a mini focus group of your jurors, All right, remember, the purpose of jury selection is to learn how the jurors in your case are going to think about the issues that are most important to you, which are the bad ones, and they're going to tell you how to prove your case. And then you have to go do that. You have to go do that. You can't be too stubborn, and you can't be too scared to not do what the jury wants. And if the jury wants something you don't have, you got to be real with them and tell them, I don't have it. I don't have it. Here's why, but here's something that you can latch onto. I think that these skills will serve you, and they've served me well in life, which is not putting my beliefs and my thoughts and the way I think things should be done onto other people. I think if you use these with your friends and your family and you ask them what they want to know, how they want to know it, arguments with people you love, I think that not only is that practice for jury selection, I think that that this is a valuable way to think about things, to respect other people's opinions, learn what they are, and then go do right by them. So my favorite juror story is one, it's a case where the jury found against me. They found against my client. They said that he caused the crash. Well, that juror worked at a hibachi restaurant here in town, which is my favorite one. And I can go to that restaurant, I see him, and we're friends, because he knows that I truly cared about what he was going to say, even in that short time. And the only way you can do that is by truly caring. So the last thing I'll tell y'all is that I truly care about you. I want all of y'all to be healthy and safe, and I want your practices to grow. If you haven't already, please email Victoria in my office. It's Victoria at Rafi, R-A-F-I, lawfirm.com. Even if I know you, even if we were texting last night, send me an email, send her an email. Please don't send it to me. Send her an email that says who you are, what your practice areas are, and what kind of cases you're looking for. I grew up with small business owners, my parents. I run my own small business right now. While my firm isn't feeling the effects of it at this moment of what's going on in the world, we are going to. I know a lot of y'all are feeling the effects now, or you're like me and going to have a delayed effect. So let's please stick together. Let's help each other. help me help you. Help me know what you do and what kind of cases you're looking at so I can put you on our referral list and send them to you when they come our way. I'm here to help you. I'm going to keep doing these webinars until I run out of things to say, which may be coming soon. I truly don't know what next week will be. If y'all have any ideas, shoot them over to me, what you want to hear about. I appreciate you spending your Thursday morning with me. And I'm going to hang here like I usually do for questions. But in the meantime, for all y'all, cutting bait and getting to work for the day, thank you. Truly, thank you. I hope I did right by you during this webinar. I hope that I kept my credibility, my honesty intact. And I hope that you think good things about me, because that's important to me. But most importantly, I hope you gain something so that you can help yourself. All right. Thank you all. I really, really appreciate it.